Hello, namaste, good morning. My name is Shubham Paswan and my student ID number is 230-17360. Now I'm going to discuss about my video presentation on international commercial law. Faction on carriers, duties and immunities. The original Hague rules were established in 1924 to regulate the responsibilities and liabilities of a sea carrier. The rules apply when the goods are transported under the bill of lading or similar document, making the terms legally binding between the shipper and the carrier. The Hague-Visby rules are a part of a broader network of international maritime convention designed to create uniform legal standards for shipping across different countries. These rules outline the carrier's duties, making the ship seaworthy, and the liabilities for loss or damage of the cargoes. They also define the shipper's right, such as receiving the compensation if the goods are damaged due to the carrier's fault. Hogg refers to the original 1924 rules Hogg-Visby, including the amendments introduced in Visby, Sweden in 1968 to addressing the shortcoming in the original rules. The Hogg-Visby rules govern contact evidence by the bill of lading, which are a key document used in the shipping industry to record details of the cargo and contact terms. The special drawing rights SDR protocol introduced a more flexible inflation resistance way of calculating compensation for lost or damaged cargoes. SDR is an IMF created international reserve assets whose values are based on the basket of the major currencies. The Hogg-Visby amendments were introduced in 1968, improved the original Hogg-Visby rule gap in the carrier liabilities, updating limit on compensation and clarifying this certain obligation. Interpretation in the Hogg-Visby rules in the English code. The Hogg-Visby rules do not provide clear guidelines on how they should be interpreted and the importance of the uniformity. When the purpose of the international rules like a Hog-Visby is to promote consistency across the global shipping. English courts may consider decisions from the foreign courts like France, US, and other signatory states to promote harmonized interpretations. When the provisions is unclear, national courts tend to interpret them through a lens of their own legal culture and policies. Scholars and the judges often advocate for more authoritative international commentary or bodies. Such guidance could reduce confusion and divergence. There is a tension between the country's desire to preserve its legal independence, sovereignty, and the need of the align with the global standard for the sake of international trade efficiencies. The court must balance the national interest with the commercial need of uniformity. Carriers, duties, and liabilities. Article 3, Clause 1 defines a carrier to include the owner of a vessel or character who enter into a contract of carriage with the shipper. Article 3 subclause 1 carriers and under an obligation before and at the beginning of the voyage to exercise due diligence to make the ship seaworthy, to make properly men equip and supply the ship, to make the holds, refrigerating and the cool chambers and all other part of the ship in which the goods are carried fit and safe of their reception, carriage, or preservations. And the next is cargo management. Article 3, Clause 2 the carrier is required to properly and carefully load, handle, stow, carry, keep, care for, and discharge the good carried. Next is the documentary responsibilities. Article 3 clause 3, the carrier is under the obligation and demand by the shipper to issue a bill of lading which contains amongst the other thing, first, leading marks necessary for the identification of the goods. Number 2, number of the package or a pieces. Number 3, quantity or a weight of goods. Number 4, apparent order and the condition of the goods. So Article 4, 3, subclause 4, the evidential value. Evidential value, such as a bill letting or shall be prima facie evidence of the receipt by a carrier of a of goods as therein the described in accordance with the paragraph 3, subclause A, B, and C of Hogan-Visby rules. However, proof of the contrary shall not be admissible wherein the bill of lading has been transferred into third party acting in a good faith. Duty of pursue the contract voyage. Article 4, subclause 4. Any deviation in saving or attempting to save life or property at a sea or any reasonable deviation shall not be deemed to be an infringement or a breach of these rules or of these contracts carriage, and the carrier shall not be liable for any loss or damage resulting therefrom. Carrier immunities. The Hogg-Visby rule provide a wide list of exceptions in favor of the carrier. Number 1, unseaworthiness. Article 4, Rule 1. The carrier is not liable for loss or a damage that is consequence of unseaworthiness, so long as he has exercised due to the diligence to make the ship seaworthy. And the next is negligence in navigation or a management of a ship. Article 4, Rule 2, Clause A. The carrier is not liable for loss or a damage to the goods as a result of an act, neglect, or default of the masters, mariner, pilot, or servant of the carrier in the navigation or management of the ship. Next is fire. Article 4. Article 4, Rule 2, Clause B. The carrier is excluded from the responsibility for loss or damage arising or resulting from the fire unless caused by the actual fault or privity of the carrier. Next, perils of the sea. Article 4, Rule 2, Clause C. The carrier is not liable for loss or damage or the goods where it has occurred due to the perils, danger, accident of the sea or other navigable water. The next is Act of God. Article 4, Rule 2, and Clause D has clearly described the carrier is not liable for loss or a damage to the goods that has resulted from Act of God. Next is Act of War. Public enemies and riots under Article 4. The carrier isn't liable for the loss from the Act of War, enemies, or a civil unrest unless due to negligence, and this includes the state hostilities, civil war, terrorists. And the next is, and next, it has been clearly described where the Hogg-Visby rules carriers are not liable for a loss from the Government Act, quarantine shipper, faults, strikes, saving life, properties, natural wastage, inherent voice proof, packing, or making the latent defects or other cause without default or negligence. Clean bills and the proof of due diligence may limit these defense. Limitation and liabilities. Under the Hogg-Visby rules, a carrier is liable for loss and damage, though the term loss and damage is not clearly defined under Hogg-Visby rules. Court has interpreted broadly to include not only the physical harm to the good, but also consequential losses such as the late or incorrect delivery. The next is time limit for claim. Article 3, Rule 6 provided the carrier and the ship shall in any event be discharged from all the liabilities in respect of the goods unless the suit is brought within 1 year of the delivery or of the date on a which would have been delivered. The next is financial limit. Article 4, Rule 5, Clause A. Unless the nature and the value of such goods have been declared by a shipper before shipment and inserted in the bill of lading. Neither the carrier nor a ship shall in any event or to be become liable for any loss or a damage to or in connection with the goods in an amount exceeded 66.67 units of the amount per package or unit 2 units of the amount per kilogram of a cross weight of the goods lost or damaged, whichever is the higher. And the next is loss of limitation. Article 4, Rule 5, Subclause E. Neither the carriers nor the ship shall be entitled to be the benefit of the limitation of the liabilities provided for in this paragraph if it is proved that the damage resulted from. There are some relevant cases. Magazine Footwear Company Limited versus Canadian Merchant Marine. In this case, the court had decided the reinforce of the principle that intentional or reckless conduct voids liability protections available under the carriage contracts. And the next case is the Muncaster Castle, 1961, AC 807, where the court has clarified that the maintenance doesn't absolve the carriers of liability under Article 3 of the Hague Rules. Now I have concluded my presentation where the Hogwarts rules apply mandatorily to contract of the carriage covered by a bill of lading when the certain conditions are met, such as issuance and or a carriage from a contracting state or express incorporation into the contract. These rules govern carrier obligations including due diligence for seaworthiness and proper handling of cargo. They provide carrier with the specific immunities for losses caused by the navigational fault, fire, not due to their fault, perils of the sea, and act of God, among others. However, liabilities cannot be contractually reduced below the standards set by the rules. Time limits and the financial caps on the claim also apply unless the carriers act intentionally or recklessly. The rules aims to balance shipper protection with carrier defenses, but not compliance and clearly in documentation remain crucial for both. I have mentioned the clear resources and bibliography in Oscola format. And the last, I'm thanking you and thank you for giving me a privilege to part of your university. Thank you so much.